Let's move ahead and discuss few more interesting provisions in the Act. So as we know that there are applicant-based special provisions and benefits available with the Patents Act. These are startup, small entity, MSMEs, and female applicant and universities. These guys are provided with cost benefits as well as expedited examinations and expedited disposal of the applications. Then there is this facilitator programs which help the applicants with their skill and cost needs. You should read about it and prepare a response so that you know how to answer the question. Then there is this patent prosecution highway or the expedited examination. Again, go through the videos. I have explained those in simple terms so that you have the keywords to create the answer in a manner that is expected from you. Then section 3K and 3D are the most controversial and talked about sections. You should read through the case laws. You should understand the reasonings from the patent office, from the court's point of view, in how can you overcome section 3K or how can you overcome section 3D, or what is the requirement of section 3D. The keywords being technical advancement, technical effect, efficacy. Write short notes so that you know what do you mean by technical advancement, what do you mean by technical effect, and what do you mean by efficacy or therapeutic efficacy. Similarly, questions around patent rights and co-applicants. Section 50 talks in detail about this. Section 47 talks about what are the activities which are not considered as infringing activities, whereas section 48 talks about the rights of the patent, right? And then interesting questions with regards to patent of addition. So the question will be directly worded in a way which would make you think that they are talking about modification, they are talking about improvements, therefore I need to file a patent of addition. Or the invention or the application has multiple inventions in it, therefore the controller is asking me to divide the application, which is divisional application. So the timelines around it, the process around it, you should create a comparative chart so that you know how divisional application is treated and how patent of addition is treated in terms of the terms of the patent, in terms of the renewal fee that you need to pay, in terms of the substantive examination or not substantive examination, right? And then of course, secrecy provisions. What happens when a secrecy provisions or on what grounds secrecy provisions is invoked, and what happens to your patent as a patentee or as an applicant? What do you need to know about it? What are the timelines around it? So you should make small notes around these questions also. This would help you to recall and address any use case questions that come. Just to help you visualize, I have captured few use cases around these also. Let's go over it. So first one says an application was filed with a provisional application by MSME. It's a small entity in Ladakh. Subsequently, the MSME made further developments to the invention disclosed in the PS contributed by Bikram, a citizen of Nepal, who joined the MSME after the provisions had been filed. The MSME seeks your advice whether improvements can be included in the complete specification. See, ideally, we know provisional specification should cover everything that needs to go in complete specification for the priority date to be secured. But what if that content was not there? In that case, we will have two different priority dates for different claims. The claims which are supported by the content in provisional specification and the claims which are supported by the current specification. Go through the video, timeline video. It's an interesting video. You'll understand that. So improvements can be included in the specification, but of course, those improvements will not have the priority date from the provisional application. Will have priority date of the filing of the complete specification. An Indian research student invents a new form of a drug for smallpox. Section 3D, new form of an existing drug. He claims that the drug is 30% more efficient than the available drugs. See, efficacy, 30% more efficient. So section 3D has this keyword of more efficacy. So you can directly imply that section 3D will be applied and there is a justification because there is an efficacy. So our invention or this guy's invention can be considered as a patent eligible subject matter. But it says he wishes to get it patented only in the USA. Advise him the necessary procedure to be carried out with the Indian Patent Office. So there is no section 3D because he doesn't want to file in India. But then he would want to file in the US. He is an Indian research student. So assuming he is an Indian resident, therefore we need to file for a foreign filing license as per section 39. We need to seek permission from the patent office. How do we do so? Go through the process. And once the permission is there, we file at the US. Now, how do we file at the US? Of course, you cannot file it. You will have a US attorney filing it on your behalf. So the provisions at the Indian Patent Office is only for section 39, obtaining the FFL from the Indian Patent Office. The next one, your client, Mr. Wise, he got a patent in India for a method of manufacturing a product X. The patent is in force from 2004. Your client has improved, underline, upon the patented method and seeks your advice for protecting the invention. Suggest him the best and economic way of the protection. So they have already told you best way and economic way, and they are talking about improvements. If we were to file this invention as an independent invention or independent application, the previous patent will act as a prior art for this new invention of yours. So the best way of protection is to file it as a patent of addition. Patent of addition can be filed anytime after the filing date of the parent patent. You can provide more details about what could be the term of the patent, what details would go there, and how do you consider this to be the best and economic way of filing for the protection. Moving to the next one. You have received a letter from the patent office imposing secrecy under section 35 of the Patent Act. Write a letter to your client explaining the consequence. So secrecy, what happens? The patent application will not move through the process at the patent office. The controller will send an intimation to the central government. Central government will take its own time to come back and tell you whether the secrecy provision should be kept going or can be revoked. If it gets revoked, then the application goes forward through the entire process of publication, examination, and finally the decision of the controller. So write down model answers for such questions so that you know how to start, what all provisions to talk about, what all justifications to give, and how to conclude your answers. So writing down the model answers is very important because it will give you enough practice to write with your pen and paper, because we have forgotten the art of writing. And in the question paper, you would be required to write a lot. So this brings us to the end of this session. And I am sincerely hoping that the session would have given you enough guidance in terms of how to understand the question and how to code the answers so that you write all the details that would make your response appropriate and substantiated by the relevant section numbers, with the details coming from the section numbers. The next and the final episode of this series will be on the drafting part. I know many of you are waiting for it, and I hope to make that section of the question also simple for you and provide you with some guidelines and some approach on how to deal with drafting questions also. So I'll see you in the next video. Till then, be good and take care.